Good morning, everyone. Welcome back, and welcome to the copyright panel. Our title is Copyright Under Pressure, What Phase Are We In? And I think that's an appropriate title. I was pushing back a little on an assessment that we are on the wane. Although if you look at what phase of the moon we are in, actually, we are at the waning crescent phase of the moon, and perhaps that's appropriate for a discussion that will illuminate us on copyright issues. So we've been waxing, we'll be waxing and gaining an illumination after this session. So we have a wonderful lineup of panelists. And I'm very glad to be moderating. I'm Sandra A-Stars. I'm here at Scalia Law and at SIP Squared as a copyright scholar and director of an arts and entertainment advocacy clinic. So I work very closely on copyright issues and with artists who experience the pressures that copyright is under. So I myself will be very interested in hearing both the empirical research that the scholars here have come to reveal to us, and also the practical experiences that the professionals from industry will share with us. So today we have Clark Asay from Brigham Young University to speak with us about some empirical research he's done. Orit Fischman, who is from the Haim Strick School of Law, College of Management, Academic Studies, and she will also be speaking about empirical research, in this case, criminal enforcement versus civil enforcement of copyright issues. Maria Palante was unable to make it today, but she is ably replaced by her colleague Terry Hart, who is General Counsel at the Association of American Publishers. And Karyn Temple is joining us, and she is Senior Executive Vice President and Global General Counsel for the Motion Picture Association. So we'll start this morning with Professor Fischman. And thank you very much, Professor. Please go ahead.
This is a joint project with Professor Baton. We're both from Israel, and unfortunately she could not attend, and we're really sorry for that. So I'm very tight in time, so I'll just start. So the theme of our project is the decline of copyright criminal enforcement and the rise of civil enforcement, particularly in the current digital age. Therefore, I open by stressing the ongoing copyright crisis. Then I'll move quickly to briefly taking stock on copyright criminal enforcement. Thereafter, I'll refer to major civil enforcement framework. And finally, I will close by proposing to reconsider the use of the criminal law. So as to the background, I think all of us know that in the last 2 decades, copyright law is facing a severe crisis. All relevant stakeholders, but I mean all of them, are unsatisfied by the legal regime. Users stress that the law is not promoting a fair and a balanced regime. Right holders, on the other hand, are blaming the regime for not being efficient. They claim that online infringements are thriving. The term copyright war that was coined 2 decades ago described this reality in which the complex interests are in a constant clash. So scholarly writings propose various ways to ease this crisis. One common path is indeed focused on the redefinition of the rights. Under this framework, there is an excessive discourse on the exceptions and limitations matters as a vehicle for promoting fairness. Another alternative path is focused on remedies, seeing this as an essential and pragmatic element in designing the appropriate regime. And enforcement is indeed a key factor in this path. So let's start with the criminal enforcement. Generally speaking, criminal enforcement in the domain of IP law suffers from many known deficiencies. The public does not perceive IP infringement as morally wrong because it involves intangible assets. The analogy to theft is not intuitive. Moreover, I think the harms are not always clear. Focusing on copyright in particular makes things even harder. The protected asset is an expressive work, which is therefore even harder to be perceived as theft. And the many uncertainties just discussed before in the copyright law and the patent law and the application of the fair use doctrine reinforces the question whether infringement is morally wrong. Furthermore, copyright infringements raises the issue of the conflicts with the freedom of speech. Therefore, the bottom line is that the criminalization of copyright law is questionable. Nevertheless, copyright infringement is acknowledged as a criminal offense, and in a gradual process in the US, more and more schemes were adopted, expanding the cover of criminalization and the level of offenses. I will not mention all this law, I'm sure you're all familiar with. I'll just mention the most recent piece of legislation from 2020, the Protecting Lawful Streaming Act, which is addressing the challenges of online infringement generated by streaming technologies, and it is significantly increasing the criminal penalties. And I think that there is much hope in the industry is that this act will be a game changer in the criminal enforcement. However, some data. So this is not empirical, it's only just descriptive statistical. Despite the constant expansion of the legal measures adopted by law, in practice, there is a clear trend in which enforcement is declining. As we can see from the data provided by the US Sentencing Commission, which I should note refers to copyright and trademark infringements together, the number of cases reported by the Commission is declining from 475 cases in 2015. It has dropped into 137 cases in 2021. Many explanations could be given, however, the tendency is clear. Another figure taken from the Department of Justice reports regarding the number of criminal charges tells us the same story. The number is declining from 45 cases in 2014. It has dropped into 7 cases in 2020. So I think the picture is quite clear. So now let us move to the civil enforcement frameworks. Regarding to civil enforcement frameworks, a line of frameworks was adopted along the last 2 decades, all aimed at addressing the emerging challenges of the digital sphere. Just to mention major milestones, of course, the DMCA, that also I think Clark will address too. Immediately after, in 1999, the Digital and Deterrent Theft Act was adopted, expanding the range of statutory damages. And I just also want to mention the most recent Small Claims Enforcement Act of 2020. And this act directed the US Copyright Office to establish the Corporate Claims Board, which was launched very recently, I think just in June. It is a small claims tribunal that provides an alternative to federal courts. Everything is conducted online with highly simplified procedures. I think there's no need for attorneys. And the overall aim is to provide access to redress for small-scale right holders. In contrast to criminal enforcement, I think that the data support that the various civil enforcement framework has been proven to be effective, though controversial. And I just skipped that. I just mentioned the headlines. So I think there's no need to explain that the notice and takedown regime that has been established by the DMCA is regarded as a highly successful framework. In recent years, these scams are operated by automated systems, such as the Content ID system operated by YouTube, and the Content ID system is regarded as quite effective in cleaning the net from infringement. It is so successful that the EU has adopted these automated systems as a mandatory framework in the directive adopted in 2019. So the Brussels effect was just mentioned yesterday, so this is another example of the Brussels effect. Yet these systems are also controversial, and they're being blamed for over-blocking. Another successful measure is the statutory damages framework. The policy underlying statutory damages is to provide an effective enforcing tool that would serve as a deterrent. The discretion that's given to court is a very broad one, and it includes a punitive approach aimed at punishing infringers, yet also the statutory damages framework is also being very controversial. It's being blamed for over-deterrence because lack of proportion between the damages awarded and the actual injury. So without addressing the controversies regarding the various civil enforcement framework, the argument, this is the bottom line, that we wish to propose is that together, all these frameworks are providing a powerful package to right holders. The aggregative effect of the various schemes is synergic, facilitating efficient enforcement. Therefore, and to the bottom line, I think that in light of the declining trend of criminal enforcement measures, and particularly with the inherent theoretical inconsistencies and the relative success of the civil enforcement framework, I think that criminal enforcement should be reconsidered. And with that, I'll end my 6 minutes.
Thank you. Professor Asay.
I, too, would like to thank Sandra and everyone else for having me. It's great to be here. I didn't even have to make my kids' lunches this morning for school, so I feel a lot of stress relief right now. So I'm going to, I've had, over the last 5-6 years, I decided to take on a number of empirical projects relating to copyright. And these are largely descriptive, right? I teach copyright, I would go to copyright panels, I would hear a lot of arguments and sort of normative claims about copyright. And not that I got tired of it, but I just wanted to dig more into the cases to see what was going on in fair use, substantial similarity, and DMCA section 1201. So I'm going to very briefly tell you about 3 studies that, right, there's a lot more detail here. So if I miss something and you think, well, this or that, chances are it's probably in the paper, maybe not addressed to your liking, but it's probably there. So I'm going to hit the highlights or lowlights depending on your view of these 3 studies in the next 6 minutes or so. Okay, so the first study I did was this transformative use study, fair use study. I took all the opinions I could find from 1991 to 2017 and analyzed them on a number of dimensions. And sort of the basic takeaway, I mean, there were a number of takeaways in there. The basic takeaway, which is not surprising sort of for people that look into fair use or study fair use, and anecdotally, is that transformative use concept, there was previous empirical studies that had looked into this, but they had sort of stopped around 2008 or so. And so I just want to take up where they had left off and see, like, how is the transformative use concept playing out? And not surprisingly, especially in later years from 2010 until 2017 when the study stops, the transformative use doctrine is really dominating fair use case law in a number of different ways. I mean, it's brought up, obviously, very frequently. Here it says 70%. If you look at just from 2010 to probably now, the percentage is higher. Now, the mere fact that courts use or rely on transformative use does not seem to predetermine the outcome. If they win the transformative use question, then they usually almost always win the case, right? But just the mere fact that courts talk about transformative use does not seem to predetermine the outcome. And there's regression results and sort of, in the actual paper that looks at this. One thing that's interesting that I also looked at in this paper was the transformative use concept it's formally, it's usually discussed under factor 1, but it also influences and discussed under factor 2, 3, 4, not terribly surprising perhaps because of Acuff-Rose and what the court did there. But it's just sort of suffusing the whole fair use discussion. And so that was, the main finding, among others, in that study. The next one was substantial similarity, and there are a lot more cases here. So we did a random sample of about 1,005 opinions with a research team. I think a pretty rigorous process of coding, independent coders for all of these opinions. And these are the things we coded for, a bunch of different things. I would say I think one of the main takeaways here was courts don't really do much on, if you are familiar with the substantial similarity test, this test that we use to assess whether parties have committed copyright infringement, they don't really do prong one. I mean, they sort of do it, they briefly mention it usually, but there's not a substantial similarity analysis typically under prong one to assess whether copying has happened. They usually just look at access. This is largely driven by the fact that so many cases are coming from the Ninth Circuit where the test has been altered a bit from what treatises and courts often recite. They usually just look at access, and it's not a hard question. It's just, sure, like, you probably had access. Let's move on to the interesting question, prong two, which is interesting in many dimensions, one of which is it's, as I think anecdotally we knew, it's a total mess, right? There's no dominant subtest, even within many circuits. Courts are sort of flailing and using multiple subtests. Experts, interestingly, are used more frequently under prong two than prong one, right? Prong one is where courts usually say, yeah, experts belong here. Prong two is for the ordinary observer. And that's still largely true, but experts are used more frequently under prong two than prong one, and I think that's because prong one doesn't really get much love or attention from courts. They usually mostly just skip it and move on to the prong two analysis. One thing that's interesting that I sort of left off in the study, or I looked at, but would need to do more sophisticated analysis on is whether a court engages with copyright limitations decision appears to make a big difference as to who wins the case. Now, you might say, well, that's because when they're relevant, court talks about them, and that sort of pushes in favor of the defendant. When they're not relevant, court doesn't talk about them, and that pushes in favor of the plaintiff. That is probably almost certainly in play. I didn't do sort of more sophisticated regression analysis on that question, but that's sort of a preliminary finding from this study that I think is interesting, worth exploring more. The final study that I am still in the process of completing, I've done all the data gathering in the process of writing up the results, is a DMCA Section 1201 study. I think the most interesting finding in this study is just there's not much Section 1201 litigation. There just hasn't been. There's less on average than one appellate decision per year since the DMCA's enactment and effective date. There are a little under 10, about 9.5 on average, district court opinions. This is including both published, unpublished, everything that's available. So not a lot of Section 1201 litigation. I have some ideas as to why. And to Orit's point, in terms of criminal enforcement, there's just not much there. There's a couple opinions, if I'm recalling correctly. There's also like music Section 1201 opinions. This is, I think, I could find 2 or 3 cases, okay, over the nearly quarter of a century of the DMCA's existence, which I think is a really interesting finding as well. The most litigated subject matter in Section 1201 is software. Software beats out audio-visual works, music, obviously, every other subject matter that we coded for. I think, again, the paucity of cases is the main finding here. Now, you compare it to the substantial similarity, fair use. Obviously, one takeaway is just, well, Section 1201 is just not as important as substantial similarity. fair use. There's obviously going to be more cases in those areas than in Section 1201. I have some ideas about that, and I think that's in part true, but also deserves additional sort of thought. I don't have major normative takeaways from these studies. I mostly did them out of interest to sort of figure out what is going on, to learn more. I do have some sort of tentative takeaways about, well, is this working? Is this not working? One of the questions that I sort of have with respect to substantial similarity, is it salvageable? Like, do we just need to revamp the whole thing? Courts don't really seem to know what's going on. And part of that might be because of, the lawyer's arguments and the briefing and so forth. It's just kind of a mess. So I will leave it there and look forward to your questions. Thank you.
Thanks, Professor Asay. I'll ask Ms. Temple to speak next, and I'll give you the option of sticking with what you had originally wanted to speak about, or speaking more broadly and trying to address some of the things that have been brought up by your co-panelists. I'll also say that once we get into the interchange between panelists, I know there's a lot both you and Mr. Hart will want to address in the academic work that's been presented. So don't feel like you have to try and get to any of that right now.
Well, thank you, and first of all, thank you to Sandra and to CPIP and to George Mason for hosting this, such an interesting title for the conference, and one I really look forward to kind of delving into a little bit more. We'll do our usual caveats that I am here in my personal capacity and not speaking on behalf of my organization or its members. But I will say, Professor Asay, did I pronounce that right? Asay, sorry. Stole a little bit of my thunder, but I will continue to talk about the transformative use piece. And then I do have a number of other questions on the other study that was mentioned. So I will hold those until we kind of open it up. But as I said, I think it's such an interesting question. Are IP rights on the wane? What phase are we in? And I think that is a question that often gets asked, periodically as we are confronted with new technologies, new artistic techniques, and new distribution methods, and we're constantly, asking what's going to happen, how are courts going to actually resolve these issues as they struggle to fit all of these new technologies, new artistic methods into our current copyright framework. And I will say, from my perspective, I'll just throw something out a little bit provocative, which is I think what often happens is, we just start making stuff up. And the courts kind of make it up as it goes along, and we try to see what happens. And I think that did happen a little bit with fair use jurisprudence, where you have the jurisprudence now that's focused on transformative use really becoming unmoored from the legislative framework and the historical case law that we have had in the past. Because when you think about it, where did the concept of transformation first arise? Was it with Judge Laval and his definitive law review article and the Campbell case? Is that where most people think that transformative arose? I see some heads shaking. I'm going to actually say no. It first actually appeared in the copyright statute itself, not the transformative use that we know now, but the word transformed and the use of the term or concept of transformation. The very definition of the derivative work right under Section 101 of the Copyright Act says a derivative work is defined specifically as, quote, a work based upon one or more pre-existing works in, quote, any form in which a work may be recast, transformed, or adapted. So the concept of transformation, I would argue, is really came about in the Copyright Act itself when you talk about the rights and the protections of what copyrighted works and later works that are built upon initial works should have. But instead now, when you think about transformation, you don't, or the use of or concept of transformativeness, you don't even think about the derivative work right anymore. You often think about transformative use when, again, initially it really was in the statute itself and it was referring to the derivative work right. So, I think that really is something that shows that IP has become a little bit unmoored, and IP rights have become unmoored a little bit over the course of the last few years. And I think it's really great that you did your study, because a lot of people always ask about, what is the data behind your belief or your thought that copyrights are kind of becoming lessened, and the protections that we had understood in previous years are not as strong as before. And I think a lot of amicus briefs actually in the Warhol case did cite two studies, which actually in your study that showed that transformation and transformative use has become essentially the only criteria that courts are using to assess whether something is fair use. And I know that our brief, or the Motion Picture Association brief cited, and a number of other briefs cited that the study that noted that in cases where fair use and transformation and transformative use is really the major issue, that if you find something is transformative, then in 90% of those cases, that's it. It is going to be found to be fair use. And that means in 90% of derivative work cases, you're probably going to find fair use, because the meaning of a derivative work is something that adds something new. And just in terms of a real world example, which we actually cited in our amicus brief, imagine, for example, a remake of the classic film Casablanca. Everything is exactly the same, but at the end, Rick boards the flight out of the city with Ilsa, and Victor Laszlo is left to be apprehended by the Nazis. That would radically change the meaning of that film. It would convert that film from a noble statement, for example, about sacrifice for a higher cause, into a cynical parable, which we noted in the brief, about the inevitable triumph of self-interest and the folly of devotion to principle. That's what we noted in the Motion Picture Association brief in the Warhol case. But it wouldn't be fair use. It would be an adaptation. And I think in the film industry, especially, people often joke that every blockbuster is now either a sequel or based on a character from before, that we don't get any more original works. That may not be true. I will say that we did note that the top 10 highest grossing films, of those, 8 were based on either sequels or adaptations of characters, previously, or fictional characters that had been written about in other instances. So obviously, you're going to be in the film industry relying on sequels. You're going to be adapting new worlds. Imagine the Star Wars world, or the Harry Potter world. It started off as a book. Something might start off as a comic, and then you have multiple films coming out later on. You have everything in terms of products, from lunch boxes to roller coasters, built on the concept of that particular intellectual property. But again, if the definition of a fair use is simply whether it adds something new, and new meaning or message, without anything more, without assessing the degree of how much that is being transformed, or whether even in making this new meaning or message the need to use the underlying work was relevant. If you just ask the simple question, is it adding something new? Again, you're right back into the derivative work right. So I would say that we are potentially waning a little bit on because of some of the ways that courts have interpreted fair use, but we have an opportunity to correct some of that a little bit with the current case that's before the Supreme Court. So we will see whether the Supreme Court will take the opportunity to acknowledge that if they really want to have a test for fair use that considers all of the 4 of the factors and just doesn't say, are we adding something new? Is it a derivative work? That will be rebalanced, and we actually will be able to rise again in terms of having a strong protections. The other thing I will just mention a little bit separately before I close, how else can we be saved? Some people think that we'll be saved in terms of copyright on the wane with NFTs. I know you wanted me to mention NFTs. It seems like a lot of people are thinking that's the end-all and be-all of the world. I will say I hate talking about NFTs just because everybody thinks it's the end-all and be-all. But I will say it's an interesting concept, as many of you know. We did have an NFT that sold, the Beeple NFT, for $69.3 million. So that suggests that maybe there is a new technology out there that will assist in licensing transactions, will allow have a new method for registration of copyrights, and we will be able to perhaps democratize a little bit more licensing and use of works. But I will say, you have to be very careful and, make sure that you understand the terms that you're getting into with NFTs, because for that $69.3 million NFT that was sold, everyone also knows, or many people also know, the famous story of the crypto group that had purchased a Dune book for $3 million, and they thought that meant that they had purchased the rights, the underlying copyright to Dune, basically to the Dune, and that they could create a number of derivative works. So I think that the jury is still out as to whether NFTs are going to save the copyright regime and make it even stronger and more protective than it is now.
I think that will give us a rich topic for debate amongst the panelists when we get to that point. Thank you, Karyn. And Terry, we'll turn to you to kind of bring our discussion full circle with some commentary on what's going on in the States in particular.
Yes. Well, thank you, Sandra, and thank you for allowing me to fill in for Maria at the last minute. She sends her regrets that she couldn't join this great conference. And I would also note I am speaking today in my own personal capacity and not on behalf of AAP, and certainly not on behalf of Maria. Unless I say something really brilliant, then feel free to attribute that to her. But I want to start with what I think is an unremarkable proposition, but which in some circles might sound a bit shocking, and that's simply that the goal of business is to maximize profits. And as businesses, copyright industries are no different. And in fact, I think their ability to do so is directly tied to the ultimate goal of promoting the progress of science and the useful arts. And so towards that end, the ability to differentiate markets, products, and consumers is critical to that goal. And so it's important for copyright owners to have the exclusive right to determine a number of things during the term of copyright. So for example, the formats that they make works available in, whether to license or to sell their works, marketing, distribution strategies, pricing, and any other terms and conditions that they might place on access or copies of their works. So the good news, if we think copyright is waxing, is that I think for the most part, the legal framework, both in the United States and internationally, recognizes these principles, right? Copyright owners have a suite of exclusive rights. Every one of them is divisible. These rights apply to converting or making available works in different formats, and they apply just as much to digital works in the online environment. And importantly, to that last point, the legal framework includes a properly calibrated exhaustion principle, or the first sale doctrine. And since the rise of the digital economy, the US government, both Congress and Copyright Office and other agencies, have repeatedly looked at the question of whether they should expand that first sale doctrine to cover digital transmissions, notwithstanding the fact that digital transmissions result in the creation of new copies. And each time they've looked at this question, they've concluded that that would not serve the goals of copyright. And quite simply, in my view, it's because digital commerce just would not work with the digital first sale doctrine. Digital copies are completely indistinguishable from the originals, and so they would be competing directly with the copyright owner's primary markets. And add to that the fact that you have an ability to effortlessly and instantly make perfect copies from digital works that could be distributed immediately around the world, just exponentially amplifies these potential harms. So that's the good news. The bad news is I think we're seeing increasing threats to this framework. And to be clear, threats to the ability of copyright owners, in my view, to pursue rational choices in how they market and distribute their works can be just as harmful as straight-up piracy. So I want to talk real briefly today about two examples within the library ebook market that I think constitute these threats. So just by way of background, since I'm talking about the library ebook market, for over a decade now, ebooks have been very popular. They've been widely available. And publishers typically work with third-party aggregators, such as Overdrive, in order to enable public libraries and other libraries to digitally lend ebooks to their patrons. So if you have a library card, chances are you're able to go online and they have some ebook offerings, and you're able to check them out, much like you would check out a physical book, and be able to read it on any device you want. And then after 2-3 weeks, whatever the checkout term is, the book is, quote unquote, returned to the library. So in order to do this, publishers employ a variety of licensing models that have evolved over the decades. They continue to evolve to meet both the needs of publishers and libraries. And today, all Big 5 publishers make their entire ebook catalogs available for digital library lending. And the evidence shows that this is a well-functioning market, right? Today, library patrons have access to more ebook titles than at any other point in history. Readership is flourishing. Overdrive, which is the largest ebook aggregator, reported that in 2021, there was over 500 million checkouts of library ebooks worldwide. And the pricing is, in my view, fair and sustainable. So Overdrive also reported in 2021 that the average cost per title for libraries declined in 2021. And libraries have been able to significantly grow their ebook collections over the decades with collection budgets that, when you adjust for inflation, have essentially been flat the entire time. So they've been able to get more for their buck. That said, I want to talk about the specific threats now in this market. And the first is what's been called controlled digital lending, or CDL. So CDL is this theory that was basically designed by academics. It doesn't come from the statute. It doesn't come from case law. And what advocates argue is that this theory allows them to make and distribute digital scans of physical books online without the permission of the copyright owner needed. And so the controlled part of this theory is a set of requirements that these academics have also come up with, not derived from case law or statute, that they argue makes the digital lending of these unauthorized scans of physical books replicate physical lending of books. And so they believe that is sufficient to make the process lawful. So under the guise of CDL, one entity in particular, Internet Archive, has been systematically digitizing and providing public access to complete copies of millions of copyrighted books through its open library program. And so in response, in June 2020, a group of publishers sued Internet Archive for copyright infringement. claiming that direct harm to both their print and ebook markets in all market segments because Internet Archive is providing competing substitutes. So that case is ongoing. Parties are currently in the middle of briefing on cross motions for summary judgment. And somewhat unusually at the district court stage, there's been a number of amicus briefs that have been filed, one in particular from an organization called the Copyright Alliance, which represents a broad spectrum of both individual creators and industries within the creative industries, noted that while Internet Archive's infringing activity is already harming existing markets for books, if the practice expands to other copyrighted works, which it very much could, such as music, film, television, video games, and the visual arts, it would cause widespread harm to all creative professionals and undermine the very purpose of copyright. Indeed, I think CDL, Controlled Digital Lending, is just a few steps away from a full-blown digital-first sale and all the harms I think that would bring to the creative economy. So the second threat, as Sandra mentioned, this is in the states. So beginning in 2021, states across the United States introduced or enacted legislation that would essentially create a compulsory license for the library lending of ebooks and in some cases audiobooks. So in addition to mandating that book publishers license ebooks to libraries, these laws, which are largely similar across states, would have done a number of additional things, including outlawing windowing, which is a common practice in many copyright industries. It would outlaw any limitations on the number of licenses offered to libraries. And finally, it would require that the licenses be made on otherwise undefined reasonable terms, which would effectively authorize any given state to dictate the terms and pricing of ebook licenses. So the advocates of these state ebook bills essentially define, in their view, reasonable pricing and terms as meaning that ebooks should have what they see as print equivalent pricing and terms. So essentially prices and terms that a print book is offered for, an ebook should also be offered under those same pricing and terms. I would argue this view is flawed because it's ultimately what they're saying is that it's unreasonable for copyright owners to differentiate formats and markets, in this case, the very different formats of physical books and ebooks in the very distinct markets of physical books and ebook lending. In other words, that the mere exercise of a copyright owner's exclusive rights is unfair. So I think these state laws are harmful to authors and publishers currently if they were passed. Fortunately, none of them have survived. One passed in New York was vetoed, and one passed in Maryland was struck down by a federal court this past summer. But I think it also creates a harmful precedent for other ill-advised encroachments into the framework that copyright owners rely on, that encourages vibrant and sustainable creative industries, which promote the progress of science and useful arts. So I will end there. Thanks.
Thank you, Terry. And thank you to everyone for your opening remarks. I had told you as we were planning this that I would give you like a wide open question as the first question. But I think you sort of answered that already in your opening remarks, because my opening question was going to be whether copyright law or the effective enforcement of it is waxing or waning overall from your perspective. And your opening remarks have more or less answered that. So what I want to do is really drill down a little bit on some of the things that each of you said, and also invite questions from the panelists as I do that to sort of jump in and answer and engage with each other. And maybe I'll start with Professor Fischman. Some of the statistics that you were showing us, I'd love to give you an opportunity to talk a little bit more since we were pressed for time. And one thing that I was very curious about was when you were talking about criminal enforcement, you were talking about the statistics, the measurements of cases, and you were measuring and counting cases in the numbers of cases filed, I think. And I was curious why you had chosen that metric rather than maybe the value of the cases or some other metric that might give us a different perspective. Because I guess I could see, well, great, maybe you filed 100 cases in 2014, but in 2018, you filed against Kim.com, and that was $1 bazillion and made a huge impact and had a great impact on the whole world of copyright infringers who saw, the PR impact of filing that case. And maybe that is really what the criminal enforcement was targeted against, was like the PR impact rather than the number of cases. So I'm wondering what your thinking was in choosing that metric.
Okay, thank you, Sandra. This is a wonderful comment. It was the obvious one that I was waiting for. And first, as to the general question whether copyright law is expanding or not expanding, I think expanding is a term that refers to something that is measurable. I mean, I cannot say whether a right is expanding or not. I can say whether enforcement or something that is measurable by quantitative scale is expanding or not expanding. Mm-hmm. So therefore, we addressed the enforcement perspective of copyright law. So the statistics, the quantitative, the counting, the statistics of criminal enforcement in the US is very clear. The numbers are declining. And now we should go to qualitative research and just, picking the cases and trying to understand what cases are the ones that are a charge and whether they're big ones or the small ones. And we couldn't find this data. So we couldn't allocate the data. What are the specific 7 cases that were charged in 2020? So we're referring only to the quantitative scale. The question, if I'm referring only to the quantitative scale, the question is, of course, is whether the mere existence of a criminal offense is important in itself, and it's doing the job in creating deterrence, or whether if there is a criminal offense which is not enforced is more harmful because of rule of law considerations and so on and so forth. So I think this is the general questions that should be asked. And of course, we should look at, the specific cases, whether, 2 big cases, for criminal enforcement are, doing the job, or whether we need the mass, of criminal enforcement. But then you should ask the question why the curve is so clear, why there is a declining tendency. So many explanations could be given. All of them are speculative. I mean, there's no way. The former panel was talking about the importance of evidence-based policy. So many assumptions could be raised. First, I'm not expert in American criminal law policies, but it might be part of a bigger picture of declining of general enforcement. I was looking at this database. I can show you all of the Sentencing Commission, the reports of the sentencings, and I clicked various offenses, and I saw that there is a similar curve with regard to the general offense of fraud. The curve is having the same declining tendency. So maybe this is a part of a bigger picture, which might be associated to reduction of resources, or I don't know what. So I think there should be much more, of course, research to be conducted on the criminal prong of enforcement. On the other side, I think that the civil enforcement prong is expanding. And I didn't have the time for exploring all the data, but for example, we can use a Google or YouTube transparency reports, the annual transparency reports. For example, just checked yesterday, and the notice and takedown regime is highly active with Google, reporting about a 10-digit number
right. And
of
that's
takedowns.
That's actually that was going to be my next question, which is that really a measure of success? That you're filing huge quantities of takedown notices. There have actually been very many hearings and rulemaking procedures, notices of inquiry at the Copyright Office and elsewhere, where artists are filing requests and testimony to testify to the fact that the 512 process is not working because they have to file so many takedown notices, and the moment that they file a takedown notice, the file goes right back up. So I'm kind of interested in how you determine the metric for success being, oh, lots of notices filed, that means it's successful, when the artist's testimony is actually the direct opposite. Lots of notices filed means I can't actually be out there producing my artwork because all I'm doing is sitting in front of my computer filing unsuccessful notices against infringements of my work. So, and I have no backup from the government helping me enforce my copyright rights.
Yeah, I mean, I would just add, I mean, I think that, that is one of the limitations. I know that it's really hard to get the data in terms of the background on the individual cases and look at it more qualitatively versus quantitatively, because just the numbers of notices filed, I mean, that goes to the probably amount of infringement out there versus the successful use of the system, because if you have to continue to file notices on the same type of work or on the same exact work over and over again, that means there is a lot of infringement out there, so there's a lot of activity, but the system itself is not designed in a way to substantially reduce that activity because there is no effective method to do so. So, yeah.
I'm curious, actually, since you're answering, Karyn, what have your experiences been, either from the Motion Picture Association side or when you were at the Copyright Office, if you had any visibility into the enforcement on the criminal side? Because I haven't been involved directly, obviously, but my impression is that the government makes sort of a big effort to inform industry of what they're doing. Like, oh, we're doing in our sites enforcement policy, and here's what we're rolling out. And they make announcements, like we've taken down these numbers of sites, and here's what the dollar impact has been, and they target it towards specific, like, big dates, around Christmas or whatever.
Yeah, no, I mean, I would say, more from my previous role at the RIAA and at MPA on the criminal enforcement side, I will say, I mean, I think it is, again, very difficult to get the data, and your data was limited to the United States and so I think that's, that also makes it a little bit difficult because when you look at, enforcement, again, there are always, we always talk about new technologies and new distribution methods. We've done a lot of, over the last 10 years, civil cases that have, I think, not successfully, but significantly reduced the amount of homegrown infringement in terms of large-scale infringement. You still have a number of infringers or people who are using, infringing services, but we often talk about the fact that, especially when you're dealing with large-scale infringement, you'll have the server located in Ukraine or Russia, and the individual behind it will be in the UK, and someone else will be and the advertising will take place through a company in France. And then maybe you'll have users directed in the United States, but sometimes you won't. So even in civil cases, it's difficult to get jurisdiction, and it kind of becomes more complicated on the criminal side. What we've seen more often is on the criminal side that you have to have global enforcement where you're using Interpol and Europol and various enforcement agencies are coming together to really address it. So when you look at just the numbers in the United States, that's a difficult data. I will say, an enforcement agency wants to have they want to have packages that are put together well, evidentiary packages that are kind of put together well, that they can, use if they don't have the resources to go out there and get every infringer. That usually means the larger scale content owners, the individual is not going to get a criminal enforcement case if they go and say my work was stolen. That's probably not going to happen in terms of getting, a law enforcement agency to be able to take it. And similarly, if it's a smaller case, again, it's likely going to be a civil case. law enforcement's not going to go after, one infringer. They'll want to go after that service. So I think, as you pointed out a little bit earlier, looking at just the numbers, it's difficult to assess because you might have one service that has 100 million visits per month. If you take that down, you're gonna, that's gonna be a significant, impact versus filing, 20 cases against one service that only has, a couple of million visits, or not even 1 million visits per month. So, and that's actually what we do in terms of assessing, even on our enforcement referrals and civil cases. We look how many millions of views or visitors or users does this service have. We're not going to expend significant resources going after a service that has one user versus a service that has 100 million users.
Right. I wonder if there are any parallels, Professor Asay, in the Section 1201 litigation case. I mean, I guess there are so few cases that maybe it's hard to say, but.
No, my preliminary thoughts on Section 1201 is just that it's working pretty well. Like, that's why there's so few cases. I think the exemption process, the triennial exemption process, addresses a lot of activities that would otherwise result in cases. I think the sort of growth of streaming services, I think consumers, early on with DRM, there was a lot of uprise against DRM, and in part, I think, because consumers wanted sort of easy options by which to access their music and other digital content. Once that became readily available through reasonably priced streaming services, I think there's been sort of a shift in sort of consumer acceptance of DRM. They're not. Obviously, there's still circumventions and infringement that happens, but I think that consumer experience has changed in a way that results in, I think, Section 1201 mostly working, I think, how it was intended to, and that results in not as many cases as we might otherwise think would arise. So.
I would say the scary thing about that is, you mentioned that 1201 is, one of the provisions that's working well. The scary thing is, well, is it going to continue to be able to work well if the court decides in a pending case about the constitutionality that the law is not constitutional? So I think that also goes into whether IP is on the wane or not, because you have they're still challenging the constitutionality of Section 1201, even though this is a provision that many people do think has operated pretty well in the practical day-to-day.
I'll just add, I think in terms of it working well, I think it's resulting in so few cases because the prohibitions have been interpreted to be relatively clear, in which case you're going to have fewer people throwing lottery tickets out there, right? Because they're like, we know what the outcome will be, so we're just not going to try it.
The other thing that I'll observe about Section 1201, having kind of been there at the drafting of Section 1201 and being in industry representing parties who were working to create digital rights protection measures that were implemented to bring out new consumer electronics formats in that instance, way back when it was DVD, then it was Blu-ray, showing my age. But I think 1201 in part worked because there was multi-industry agreement both on the formats, on the fact that the consumer protection measures, the digital rights measures would be consumer friendly, right? So nobody really wanted to slow down their products, obviously. They didn't want to it wasn't like a consumer feature, right? And so they wanted to make it as cheap as possible and as consumer friendly as possible so that consumers wouldn't notice it. It wouldn't become a bug in the product. And so I think the products worked well. The negotiations between the industries to create the DRMs worked well. And so the statute was there as kind of backup to an already well-understood industry and consumer agreement as to what was expected. And that would be a great model for things like, protection measures for, Section 512, and that just never came to pass because there was no benefit that the folks having to implement protections on websites, for instance, saw, right? They were already getting the content without having to implement any protections. So why bother having an industry agreement in the first place?
If I may,
Yeah.
add, I just wanted to join Clark's comment. I think that the new business models are the big story in the copyright market. And I think, services like Spotify and Netflix, we know the micropayments business model that allows you a legal access, I think it's a game changer in the entire ecosystem of the infringement. I think this is also maybe the answer to the Ebook controversial. And, I understand the critical, I'm not familiar with this proposed law, but I think maybe modeling, like a kind of a Spotify for ebooks, could be the appropriate solution, for a global perspective. And just following up on Karyn's, on the global perspective, I want to go back to Article 17 of the European Directive, which, sets a mandatory scheme of takedown. And this also a comment to Sandra, your comment about the business being so busy with sending notices. So the systems is proactively, locating, allegedly infringing content, and it's automatic takedown with no need for notice. It's an automatic takedown. And the European system also adopted a stay-down mechanism. And also, I wanted to add about the global ecosystem, the blocking orders that are issued in many European countries, and as far as I know, also in the US, there are two blocking orders. One, the Russian science illegal content, the court just granted a blocking order.
There's nothing like that in the United States.
No, we have side blocking in the U.S.
No, international injunction was granted in this case. It's the one and only case that was granted in a blocking order. I think
if you're talking about a recent case, it might be
3 years ago. But the C-Hub, I think there's a Science Hub.
There may be a order issued, but it's not being implemented as far as I know.
Anywhere in Europe and also in Israel, the blocking order is the most popular remedy, and it functions very well.
I would agree.
Yeah.
Wholeheartedly.
Yeah. I think it is something that many people have suggested as a model, but it has also been opposed by many people as a model here in the United States. So I think that would be a very interesting contribution if that's in scholarship that you're working on, to hear how that's working, and if that's a proposal that would be a combination with lessening criminal enforcement, increasing notice and stay down type provisions. That's a very interesting suggestion for sure. And Terry, I wanted to invite you to weigh in on your thoughts, particularly with this business model discussion and how the combination of having a useful business model that everyone sees some benefit in, consumers, all the parties offering business models of various types, how that can lead to a beneficial solution in various of these policy debates, whether you've seen that play out, whether you're seeing any potentials for solutions of some of these state problems that you've identified, or whether the CDL and state issues just are a breed apart.
Yeah, I mean, it's a great question, at least, and I could only kind of speak from the book side of things. And I'd point out, because it's interesting, and a lot of people are a little surprised to find this out, but at least in the trade side of books, fiction and nonfiction, print is king. It's, I think, anywhere between 70 or 80% of revenues today. And the percentage of revenues from ebooks has actually been declining over the years. So there's a good portion of people that like ebooks, but unlike as we've seen in other industries, there hasn't been this general trend away from physical media towards digital. So I think certainly every publisher is interested in trying different business models out, experimenting in the marketplace, but at least on the book side, it's been print has been pretty predominant, and it seems pretty lasting. But on the library side, as I mentioned, there's a number of models out there, both from what you might think as the traditional model, where a library decides we want a copy of this ebook to lend out, and they'll get a license that allows them either a certain number of checkouts or a certain time period to offer it, that way. Or they might say, it's a less popular book. Maybe we want to pay per circulation, so we don't want to buy a book up front, but if someone checks it out, we'll pay a fraction of that. And there are some models out there that kind of look a bit like a Spotify or a Netflix for ebooks, at least for libraries, where they're offered a suite of titles that are available to their patrons, and they pay either a fixed rate or base a number of circulations from within that catalog. So those are certainly out there on the marketplace as options. Just from the consumer perspective, I haven't seen any of that model really catch on. I think there's been attempts certainly over the years for a kind of an all-you-can-eat subscription model for ebooks, but I don't think they've really had a lot of broad uptake. But certainly I think that's in the minds of many publishers about whether to try that. But one thing I'd point out is is that I think it's healthy for these decisions to be happening within the marketplace. And so when something like CDL comes along, it kind of disrupts that process. And now you have, whoever's employing it, in this case, the Internet Archive, is saying, no, this is the model that we're going to do, whether or not, anyone else likes it. And, that really disrupts things, because you're offering a competing free substitute. And maybe people do that instead of buying an ebook. Maybe libraries will say, why do we have to buy ebooks when we could just give them away for free? And then maybe there's people out there like, well, I normally love print books over ebooks, but now I have the choice between buying a print book or getting the ebook for free. Yeah, maybe I'll the ebook, I don't like it as much, but it's free. So there's some harm there to the print market. So I would just note that I think, we continue to see these business markets evolve, and I think that's the natural course of things. But when you disrupt kind of the underlying legal framework, then you disrupt that process. And I think, in the short term, maybe consumers might get some benefit, but it's really not good for long-term sustainability of the businesses and the authors.
And I see we have questions in the audience, so I'll invite people to come up to the mics as they are inspired with a question. Please.
Hi. It's on?
It should be. You might have to get close to it.
Hi, I'm Nicola Searle. I'm an economist at the Institute for Creative and Cultural Entrepreneurship at Goldsmiths, University of London. Business models are one of my favorite topics, so delighted we got to that in quite detail. Just from a personal perspective, my stance on business models has changed over the last few years, because I'm starting to see that there's wider shifts happening that's going to make it more difficult for the creative industries to kind of support their outputs. So I have two questions. One is, in the UK right now, we have a large discussion about the economics of music streaming. I think we're talking about music first, because it tends to be the sort of at the coalface of some of these changes. But we'll probably get to this in other digital media later. But one of the concerns is, how is this sustainable when artists for streaming are getting such poor remuneration? So how do we make this sustainable for artists if the amount of income that they're getting off of streaming services is so little? So that's one question. And that's a business models question, of course, because that's a big shift in what we saw over the years. We've ended up with streaming. But the second part of that is we also tend to think of streaming as kind of solving the problem. And I'm not talking obviously about YouTube. I'm talking about paid for subscription services. And there's an economist called Ruth Towers who's been working on the creative industries for her entire career. And she's recently written a piece that suggests that actually what's going to happen is because Spotify isn't profitable, because these streaming services have such high costs and low revenue relatively, that what's going to happen is that the creative industry, so all these digital media are going to end up being content generators as a subservient industry to the tech platforms. So that we will end up with not standalone business models of streaming services, but that the big tech platforms, and this also continues some of the discussion we've already had today, that they'll end up so that the big tech platforms who have much more diverse business models, who work across several sectors, and their streaming platforms serve the other business models, that will end up with a subservient industry so it's a bit depressing, sorry. So my two questions is, how do moving to this streaming model, how are we going to make this sustainable, both for the artist, and what does this actually mean long-term for the creative industries?
I'll let any of you answer.
NFTs.
That's a good one.
Everybody just has to say that. Yeah.
I mean, I will say, I do think, I'm not going to speak on the music side because I've been long gone from the music industry, but I do think that, just to go back to the content protection themes that I was talking about, I think creating a legal framework for legitimate content to be profitable is going to, be key. And so even, I know you're talking about Spotify and actually legitimate services being able to pay artists, but it's difficult when you are competing with free. And so, I think making sure that legitimate services can become profitable by not having to compete with free is one way to ensure that you are able to pay artists. I think that you're right in terms of some of the trends you might start seeing in terms of, content just being a loss leader for big platforms. And the question is, do you really want that to be the case? And you have, cases like, Amazon, which I don't think makes as much money from Amazon Prime as they do from, obviously, their major business. And you want to be able to, have a society that still has, the focus on artists and creativity and doesn't only have content being a loss leader for some other business. So I don't have an answer for you other than hopefully we have strong legal frameworks that continue to be in place to address the piracy problem at the very least. But it is a huge issue, I think, that we're going to see more and more of.
I have to say one thing that's been my hobby horse for many years, which is we have to start with the language that we use when we talk about the works of authorship that we create and stop calling it content, because we are buying into the fact that we're nothing but X's and O's, ones and O's on some streaming platform. So we create music, we create films, we write literature and poetry and autobiographies, right? And this is a theme, actually, that Maria Pallanti, I think, would have raised if she were here, because I know she feels as passionately about this as I do. But the more we talk about being content creators, the more we make ourselves subservient to tech platforms. So, sorry, I'll get off my soapbox.
So I'll just add
She would have kicked me under the table probably several times.
I could feel her kicking me under the table. Yeah, if I could channel her, one thing we're really sensitive about in these discussions is whenever, there's these kind of threats to the legal framework, this idea of treating books or other types of works of authorship as commodities or some kind of fungible thing that, it's just like an input for tech platforms or something else that's completely interchangeable. And really, we are talking about, works of authorship that, can inspire and educate and entertain us. And yeah, so we try to keep that front of mind and see what are the frameworks that support, them as works of authorship and not just kind of, commodities that you scan through, flip through with your phone and forget about.
And on that note, Mike Bynum, who is an author of books and whose works of authorship have been commoditized by Texas A&M, and who is petitioning the Supreme Court to take cert on his case, arguing over issues of state sovereign immunity, has a question for us.
Yes. Professor Fischman, I wanted to give you some more background to help you better understand about the numbers. In 2018, the U.S. Attorney's Office in North Alabama had authorized a criminal copyright lawsuit against Texas A&M University, subject to the CSEP's office at the DOJ prosecuting it. We have a big meeting up here in D.C. I have two attorneys that are former U.S. attorneys representing me, the former head of the National IPR Center, and we also flew up David Nimmer from California, the #1 copyright reference person in the U.S.
The Bible.
Yes. And they all recommended to CSEP to prosecute this case. CSEP came back to us and said, we don't have enough people on our staff to prosecute a case like this. And also, we were getting ready to run out of time under our 5-year window to do that. And then President Trump closed down the government for about 6 weeks, and that closed the door on that. But to answer your question is, the reason why there's not a number of cases being prosecuted, it's not because the willingness of the U.S. Attorney's Office, it gets up to the DOJ, and they just don't have the personnel to be able to prosecute these cases. And so to see it drop down to 7 is an end result of some decision made 5 or 6 years ago to lessen that staff. Because if you don't have enough people lined up to prosecute the cases and take it into the courtroom, then you're not going to be able to, see those numbers at a sustainable level. So that's what I just wanted to share with you is that, that there's more information about the numbers than what you may see at first glance. And to me, what Terry and them have been involved with in prosecuting these states for what they were trying to do is very important because you have to hold people accountable. And if you don't do that, then they'll just get away with murder. And to give a perfect example of that, I come across a book of mine that I created 27 years ago, but didn't publish. Yet I find it on ABE Books being offered for sale 18 months ago. And we ended up finding out who printed it and published it without my permission or knowledge. I didn't know anything about it for 25 years. And we're now suing them under the discovery rules because we finally find out about this and we're prosecuting them. And that's the way you have to hold people accountable, is that when they're stealing from you, you got to stand up and go after them and, let them know that there's a right way and a wrong way. So I just wanted to share that with you because there's more to the story. And if you stand up for what we are doing in Maryland and New York, you're going to hold people accountable, and they're going to learn from that. So anyway, I just wanted to share that with you. Thank you.
Thanks, Mike.
So, thank you for the reflection. I think that what you provide is an explanation to the low numbers. It's 7 charges, they're extremely low numbers. So the explanation that you provide is the insufficient resources. So what my stance is that, given there's the insufficient resources for public criminal enforcement, the question why not using the civil framework, which is also making people accountable for illegal activity. I mean, accountability does not mean necessarily criminal enforcement. Accountability could be enforced through civil framework. So this is the stance that we propose.
Yeah, I would just add on the civil side, obviously, this is an issue that we have studied and debated for a long time. That's why the Copyright Claims Board came about, was because, yes, civil is an option for large companies, but civil is not necessarily an option for individual authors. It is just horrendously expensive to litigate a civil case. So if you have a situation where CSIPs is not going to take a case because they have to prioritize because of their resources, and you're only left with civil, but then you can't afford to litigate civilly because you're an individual author and you don't have a large corporation behind you, then you're left with no remedy at all. So civil is not necessarily, I think, the end-all be-all for most people because of the complexity and the cost. Hopefully, the Copyright Claims Board with the small claims court will actually allow more individual authors to take advantage of holding people accountable civilly. But we'll have to see how widely that gets used and how effective it is.
Yeah, that's a very important addition to the tool chest, and something that a lot of us worked very hard to see enacted. I'll add, just from personal experience, that there's actually a huge swath of independent creators and small businesses that fall kind of through the cracks because they make too much money to benefit from pro bono services offered by legal aid type clinics, and don't make enough money to be able to afford private counsel from a law firm. And so I'm lucky enough to work at a law school that allows me to operate a clinic, a legal clinic, where I don't have to have means testing. I can take an artist that makes $30,000 a year. Imagine that, $30,000 a year. That's the cutoff for people at for most pro bono services. If not you, but your whole family, if your family of like 4 people makes $30,000 a year, you typically don't qualify for pro bono services. And if you're a small business or an artist and you're actually a working artist, don't you want to be making at least $30,000 a year? And if you want advice on copyright issues, you want to do the right thing, you want to license work from other people, you don't want to infringe other people's rights, you want to, be a good player in the marketplace, you need legal counsel, right? So, but that's going to be a problem on the enforcement side too. If you can't find somebody to help you figure out how to use the services that are out there, you're not going to have civil enforcement.
But I think that
by individuals.
The procedures are very simple. I saw that the form, it's really very, very simple. It could be filled in, with simple language, I think.
Yeah, and then you serve
that was the
process,
point,
and
yeah.
No, I agree. It's more simple, but still challenging. If you can't if people have challenges serving DMCA notices on the internet, I can guarantee you they're going to have challenges using. Finding the time to use the services that are out there. So you need a whole basket of resources to offer everybody. But let me turn to another question before we're out of time. We've got a couple more minutes, I think, for one more question.
Sure. Antigone Payton, I'm in-house counsel at a technology company here in the Tysons Corner area. I think this question is really for Karyn, but I'm happy to take other thoughts as well. Karyn, like you, I'm not a big fan of NFTs, right, and all the hype around NFTs. Banksy, Beeple, while the big houses that are focused on art are all in, the speculative market is not very interesting from a copyright perspective. What I do find interesting is what's happening with this concept of rights on blockchain. So as one example, the Sony pilot project to manage their digital assets on blockchain to make sure that they had a better methodology to pass out licenses and protect their rights. That's a really interesting use of blockchain technology. The concept of democratization came up during this discussion, right? So we have these bundle of rights that are divided up with different parties who are responsible for licensing and enforcing those different rights. So when we look at some of these platforms where artists are getting on the platform, going direct to consumers, and as they mint their art, being able to identify what royalties should come back to them after each and every exchange, which occurs automatically, right? Or decentralized autonomous organizations coming together with a common purpose of buying rights to a copy of the Constitution or something else. I think it's a really interesting way to think about copyright. And so as we think about traditional protections and we think about some of these technological innovations, I have two parts of this question. Number one, do you think that this is, in what ways do you think this is a threat to the traditional themes of copyright protection and enforcement? And number two, on the flip side, what opportunities might arise from these new ways of dividing up rights, transferring rights, and how might that help with some of the issues you brought up today?
I guess I'll try to start answering the question just because you initially directed at me. I will say, I think, there is an opportunity there, certainly with the blockchain and with NFTs. I think the concern I would probably raise for us as copyright lawyers is that we just need to make sure that people understand what you can and can't do, what is being conveyed and not being conveyed. An NFT is just a certificate of authenticity. It's basically a smart contract. It's not the underlying work. It's not and the rights that you're going to be giving through it can differ, but people don't quite understand that. So I do think it's going to be a very potentially useful way to democratize licensing of rights, and we can give just a few rights, and you can, and especially as more digital art becomes, more prolific, and it proliferates more and more, I think using blockchain and NFTs as a way to, be able to catalog all of the rights that you have and make sure that you have licensing and distribution and compensation down the line. So it might, for example, allow us to have that resale royalty right in some way that we've not been able to have before, because you're able to connect and have the original artist have, grant the rights and have downsell compensation through whatever kind of licensing mechanism they use within the NFTs. But it's going to also cause a lot of litigation, I think. There's already litigation. Are NFTs covered by existing contracts? When an artist grants their rights to a movie studio or others, are they granting their quote-unquote NFT rights? And so I think it's going to take some time for the law to catch up, but I do think it is potentially a very useful tool that will help artists to be able to directly license their works and to be able to license certain rights without licensing more. But I think we just have to understand it more and make sure the artists understand what they're giving up or what they're keeping when they're using NFTs.
So I think we're at the end of our time, but I'm going to give every panelist 30 seconds to give us a closing word on what we should keep in mind as we think about whether we are waxing or waning when it comes to copyright. And I will start with Professor Asay.
Sure. I just want to go back to the business model question. I do think that in terms of IP rights typically wane when we sort of don't keep up with the technology. To the extent that we keep up with sort of technological developments, I think IP rights are more secured and tend to wax, or at least stay stable.
Thank you.
Okay,
Professor Fischman.
I think that we're both waxing and waning. In some perspectives we are waxing, in other we're waning. I share the thought that I think the future is the business models, and closing with the NFTs, just being a little bit provocative, I think NFTs has nothing to do with copyright. I think it's more similar to securities commerce. It's a contractual issue more than a copyright issue. And maybe talking about, the business models, maybe we should evolve the markets into, kind of a securities or a stock exchange of, some very metaversic
all about
conceptions.
licensing.
Yeah.
I will say, I started off by saying I think it is on the wane, and I will stand by that for now, although I will say that, I think, the pendulum constantly swings as we deal with new technologies. I do feel, as, the Second Circuit even itself said, at least in the fair use context, that, you had reached the high water mark, they had reached the high water mark, I think, in the Karyn case. And so I think it gets to the point where people start recognizing how much the protection has limited, and then start going the other way. And so I'm hopeful that that has now taken place. We've reached the high water mark, and we're going to start waxing and not waning.
Terry.
And I get the last word. I would say, I'm always a cautious optimist, so I'd say, maybe we are waxing. I think if the courts keep getting it right and keep going back to the underlying principles and the legal framework of the Copyright Act. And I do feel a lot of courts have been getting it right lately, so that's been encouraging. But I think they need to remain vigilant against threats to that legal framework, especially ones that are kind of smuggled in as, as sort of, the public interest. And there's, we should certainly hope that courts have the public interest in mind, but the worry is that they'll lose sight of the public interest that copyright provides to our society. And so as long as they don't lose sight of that, and as long as the remedies available for copyright owners continue to keep up with what's going on in the business world and in the broader culture, then I think we're waxing.
Well, I thank you all. I remind you that Sunday is the new moon, so take that for what you will. The new moon is very dark, but then we start to wax. So thank you to the panelists.